gentlemen, it's my privilege to introduce to you our distinguished guest. I think Valparaiso University, and I don't think, I know, that Valparaiso University, and particularly the School of Law, is indeed fortunate that Professor Neil MacCormick is in our midst. And that for at least two reasons. First of all, he almost didn't get here. I'm not going to bore you with all of the details, but I thought I would tell you briefly of the difficulties he's had in the last 24 or 48 hours. He flew in from Great Britain and ultimately to Toronto, and was to take an Air Canada flight to O'Hare and arrive there shortly after 6 o'clock on Sunday. He called in the late afternoon on Sunday and said that the United States immigration authorities wouldn't let him into the country because he was receiving an honorarium and he needed a worker's visa or something like that, or a permit of some kind or another in order to cross the border and come into the United States. He even offered to honor or to forego the honorarium, to which an immigration employee responded, "How do we know that you will act honorably?" Well, after what seemed like hundreds of telephone calls, most of which were made and taken by Professor Hiller, he finally was permitted to come into the country, and this is about mid-afternoon on Monday, yesterday, and even, incidentally, to accept the honorarium. Talk about bureaucracy. During one of our telephone conversations, Professor MacCormick said to me that when he had a similar engagement in New York a few years ago, he had no trouble at all, which I think just goes to prove that when you go to the Big Apple, sophistication reigns, and the trouble begins when you try to come to the Midwest. The second and much more important reason for our good fortune is that we have in our midst so distinguished a scholar and jurisprudent as Professor MacCormick. I didn't realize that these were going to be distributed at the door today, and I assume that most, if not all of you, have seen this, the brochure announcing the lectures, and also included therein is a brief biographical sketch of Professor MacCormick. But for the record, at any rate, and for those of you who haven't seen this, Professor Neil MacCormick is a Regius Professor of Public Law at the University of Edinburgh. He has degrees from the University of Glasgow and Oxford and a Doctor of Laws from Edinburgh. He is a barrister of the Inner Temple. He was Dean of the Faculty of Law at Edinburgh from 1973 to 1976 and will resume that position in October of this year. Professor MacCormick is known internationally. He has lectured in many countries, including the United States. I alluded earlier to his visit to New York a few years ago, and it was there that he was the Dewey Lecturer at New York University. Professor MacCormick is a very prolific writer, books, chapters in books, law review articles, including one, I am happy to say, in the Valparaiso University Law Review. I do not exaggerate when I say that a bibliography of his published works is as long as my arm. Many of his writings are analyses and critiques of other legal philosophers. They are penetrating and sometimes, one might think, a bit devastating. But however critical writing might be, there is always an aura of kindness and humanity. His writings might be compared, or he might be compared, to what Professor Gene Rostow, who incidentally is an old acquaintance of Professor MacCormick, said of the argumentative and analytical approach of his, Professor Rostow's late colleague, Richard Donnelly. His cuts, quote, his cuts and thrusts leave no wounds, end quotation. It is my great pleasure and distinct honor to introduce to you Professor Neil MacCormick.
Professor Bartelt, ladies and gentlemen, it's my very, very great pleasure to be here today. As the wettest of wetbacks in the state of Indiana, I suppose it does call for either a very special sort of professorial battiness to try and get in on the wrong visa, or indeed a very particular kind of arrogance to see if the people really want you so very badly that they'll spend a day persuading the US immigration to let you in on the wrong visa. But I hope you will think it more on the side of the batty than of the arrogant. It is, as I say, a great pleasure to be here and a great honor to accept this invitation to give the Seegers Lecture of this university. I'm sure it's right to pay tribute to Mr. Edward Seegers, whose generosity to the university has led both to the endowment of a chair in memory of his parents and to the creation of this lectureship. That it's been a lectureship in which people of the caliber of Tom Schaffer and Harold Berman have already taken part, and so very, very distinguished a man as Eugene Rostow is to take part next year, enhances, as though it needed enhancing, my own sense of the outrageous honor done to me to include me in this list, and I am very glad that this has been done. Also, if I may say so, to visit this very beautiful campus is a very great pleasure indeed, and to visit the state of Indiana for the first time in quite a few years. For the first time indeed since, as I learned today, English was adopted as the official language of the state. This puts me, of course, at once at a grave disadvantage, as you will already have noticed, since I speak a kind of funny dialect somewhere related to English. If I become unintelligible as a result of this and break the law and start speaking not the official language, you will no doubt cough or otherwise draw this to my attention. If I become merely boring, I authorize you now to look pointedly at your watches, and if I become extremely boring, to shake them. A forest of quivering hands already, I think. Well, now, enough of this, except one final to Professor Bartelt, Professor Hiller, and others on the Seegers Lecture Committee for all the kindnesses and services they've done in helping me to get ready for this ordeal by speech. And the speech is to be about, as you know, and let me just make absolutely sure I get this right, a moralistic case for a-moralistic law. A moralistic case for a-moralistic law. You might well ask why on earth somebody should call a lecture this title, other than a liking for catchy, or what he thinks to be catchy phrases. Why should this be a topic worthy of this distinguished series of lectures? How could one deal with this over two connected lectures? The answer to that is that, as you perhaps all know, there is a great atmosphere at the present time of argument for what is sometimes called legal moralism. Arguments that we need to be improving the moral standards of the law and improving by law the moral standards of the community, and that we need to be articulating moral majorities and through the moral majorities improving the quality and nature of our law. As it were, the appeal is for a remoralization of law against what is seen by many to have been mistaken liberalization of it over past decades. And so the question is an urgent one, whether one should or should not defend amoralism. Can one make a case against legal moralism? And putting it in what I hoped was a catchy way, that comes to the question, can one make a case for legal amoralism? It is, as I say, a present question. The same newspaper article as revealed the current state of the law and the official language of this admirable state of Indiana also tells me that a law has been passed revising Indiana's law for drunken boating and to provide penalties for boaters who refuse a chemical test for intoxication. It's nice to know that the old sea shanty question, what shall we do with the drunken sailor, has at last achieved a legislative answer, and I'm not sure. I get this fantasy idea of the bottom right-hand corner of Lake Michigan being full of the nautical equivalent of Skid Rows. and I'm not absolutely certain. It's a wise measure to protect honest and sober sailors from clashes with drunken colleagues, or whether it is just a matter of trying to up the standards of gentlemanly and gentle personly boating on the bottom right-hand corner of Lake Michigan. It may be something to do with the move towards legal moralism. More seriously, I would quote from Professor Levenson's most interesting and, as will turn out, further relevant inaugural lecture in this university, where she remarks that in relation to religious disestablishment, although over the years the court has fairly consistently sought to maintain the wall of separation between church and state, recent decisions indicate a disturbing trend towards erosion of the barrier. The decisions come at a time when the moral majority, as well as the administration in power and certain vocal congressmen, clamour for prayer in the schools, censorship of instructional material on moral grounds, and generally religious solutions to difficult problems such as the abortion issue. And the argument continues in that vein. So that, as I say, I think I'm right in putting it to you that the issue is a live one, it's a current one, it's one that matters to us all, and the question that I'm putting is whether we can make out any kind of a case for legal amoralism. For some of us, myself included, are unhappy about legal moralism. We see a tendency in our times to what one might call an attempt to procure some kind of moral establishment, paralleling the religious establishment which this great republic has always forbidden. We feel almost that there should be something like a pre-First Amendment, saying not that Congress shall make no law regarding respecting an establishment of religion or prohibiting the free exercise thereof, but rather a fortiori of that, we are inclined to think that it should be that Congress shall make no law respecting an establishment of morality or prohibiting the free exercise of moral conscience. So perhaps it wouldn't be too strong to call those of us who are apt to argue this way legal amoralists. People who think that law and morality don't have to be the same thing and should be kept distinct. And that is the definition of legal amoralism that I'm going to use in this and tomorrow's lecture. That law and morality don't have to be identical and should be kept distinct. It may be helpful to me if I may put it on the board. If so, I better have my notes. Thanks very much. So that's the thesis that I'm taking as the target or the topic in these lectures. And the next question is how one could go about making a case for this view. What kind of a case would it have to be? Well, I guess it would have to do two things, because there are really two sentences here, two parts to this. We might label that one point 1 and this one point 2. First point, that law and morality don't have to be identical. And to make out a case for that, one would have to do some investigation of what law in its very nature is, showing that it isn't identical with, and isn't even just a segment of morality. That would be the first thing one would have to do. And secondly, one would have to show how law, having the nature that it has, ought to be framed and used. We'd have to discuss what the content of law ought to be and why it ought not to be made. The same thing with morality. The trouble, of course, is, the difficulty is when I start asking what kind of case it's going to have to be to make out this argument. At least at the second stage of the argument, we're going to be talking about how law should be, what the content of law ought to be. And that suggests, to me at any rate, that the sort of argument we're going to have to make out, at least at the second stage of this, is going to be a moral argument. Arguments about the right or the justifiable use of powers of government, argument about the proper use of the powers of coercion and enforcement vested in a state. That's going to be the kind of argument that will be involved on the second phase of this at least. No doubt these will not be, or not in the first instance be, arguments of our own personal morality. There will be arguments about political morality, how people ought to behave towards each other in political society. But of course, morality is a seamless web. There's no radical discontinuity between our concerns about how we should live our own personal lives and our concerns about how the members of a community ought to live together. So although there will be particularly arguments of political morality, there will be moral arguments. And that does seem to suggest that anybody who is trying to be, in this sense, a legal amoralist confronts a kind of a paradox. The paradox being this, that those who argue the case for a-moralistic law must themselves make a moralistic case. So that this lecture will have to be a moralistic case for a-moralistic law if it's going to work at all. But if that's what it has to be, doesn't it immediately open the door to a very obvious and very fair reply from the legal moralists? They will say to me, it's not after all a question whether to keep law and morality distinct. Either way, we're going to use moral arguments in deciding what the law is to be. And it will either be your moral arguments, MacCormick and you amoralists, or it will be ours, we of the moral majority. So that all it is going to be is a choice of whose morality, not seriously, a choice whether there could in any sense be a moralistic law. So it seems then that there is at least a paradox against this. paradox that the case for it is going to have to be a moralistic kind of a case. Not merely that. Not merely that. In addition to there being a paradox, there are also two problems. You see, I'm stacking the dice against myself from the beginning. This is really a sort of factitious attempt to give these lectures a sort of soap operatic quality so that I can deliver myself an audience tomorrow. Anyway, let me stack up my problems. The first problem is the problem about the need for the justifiability of law. It runs like this. Surely, one is asked, surely all laws ought to be morally justifiable laws. You can't just have law how it is and not even go into the question of moral justifications for the laws as they are, wherever they are, whatever they are. Because always, laws are into doing, as dear old Hofeld would have told us, roughly one or other of four things. Laws are either requiring us to do things under sanctions, thou shalt not drive thy boat under the influence of drink, and so forth. Or they're letting people freely do things which have effects upon other people. In Scotland, drunk boatmen are a thing of everyday experience. And attend that they don't get breathalyzed. Or the law is about enabling people to procure effects on themselves and on others, while the agencies of state stand ready to enforce and implement the results of exercises by citizens of legal power, as in contract law and corporations law and trusts and wills and all the rest of it, where we can do things and the law will take cognizance. And even grander, in the public law, we can pass legislation, we can lay down decisions, we can exercise beneficial discretions and let people into the US on humanitarian grounds. And as Professor Hiller was pointing out to me at lunch today, of course, every enablement is also a disablement because somebody else is stopped from saying that's not law. Or finally, of course, the law can be restricting such abilities, as in the case of the First Amendment itself. Even Congress can't do some things. It can't pass a law respecting the establishment of religion and so forth. So in a wide way, all laws, since they do one or other of these four things, regulate how people behave, or how people have to behave, or how they may or can treat each other and get away with it, or have the state's coercive support. Always law is about regulation. Always in the background, there is the idea of the enforcement of regulations, or the permitting people to do things which are at least quasi-coercive without impeding them. So that either the law is coercing or it's letting people coerce. And most of us would say that all coercion is prima facie objectionable and therefore calls for some justification, and the justification has to be moral justification. So despite all this legal amoralism stuff, we all, legal amoralists included, seem to want that law be morally justifiable. So problem number one might say, is the problem of the need for law to be justifiable. Let me put these two problems together. I'll call it A, actually, to avoid confusion later on. I'm now abbreviating moral to M. Problem of the need for moral justifiability of law. The second one is rather a closely related one, the problem of the desirability of obligatoriness of law. We want it to be the case, don't we? Most of us do. I certainly do. Want it to be the case that citizens don't merely conform to the law because or to the extent that they are deterred or terrorized into it by threats of punishment, or indeed cajoled into it by promises of selfish advantage. We would like it to be the case that they obey the law out of a sense of reciprocal obligation with their fellow citizens, and indeed that they should in fact have such reciprocal obligations. We would like the idea of the law not merely imposing what it says are obligations. We would like it to be the case that legal obligations really are morally binding upon us. And this seems to be a condition of a good commonwealth, or it seems to me to be. Now, I'm aware, as I say this, that I am indeed British. Well, it's in a manner of speaking anyway. And I have the high authority of Professor Hiller in a late article of his to say that if one watches the British long enough and carefully enough, he will notice a more than coincidental connection between their respect for the law and their cultural preoccupation with sports, with playing the game according to the rules. And indeed, he says in a footnote in the same article, the very nature of the rules or the structure of particular sports is revealing. Who but the British could have devised a game like golf, which, while it requires that the ball be played where it lies, frequently in a difficult position, often out of the view of the other players, nevertheless allows each player to keep his own score and has no referees or umpires? The answer to the question, who but the British, is the Scotch. On the other hand, is it significant, he asks, or pure coincidence that in baseball, the true American game, it is all right to steal a base if one doesn't get... Well, I see no reason to challenge Professor Hiller's sociological observation. So it may be that my second problem has a specially British feel to it. But I don't think so, actually, because it's a problem with which David Lyons and others have been beating me about the head in the periodicals for some time now. So, the second problem, is that, joking apart, we all, I think, regard it as a condition of a healthy commonwealth, a good society, that legal obligations be really obligations which it's morally incumbent upon us to carry out. We want it to be the case that a good human being can also be a good and law-abiding citizen. We want the idea that law-abidingness is a virtue to be true. And that can be true only if legal obligations really are morally obliging. And this looks then like a second heavy problem for would-be legal amoralists. So that problem B of the, let's call it the desirability of obligatoriness of law. How can we hold to this thought that it's necessary for law to be morally justifiable? How can we hold to the idea that it's desirable for laws to be really obligatory, and also go on trying to be legal amoralists, trying to say, as the board puts it, that law and morality don't have to be identical and should be kept distinct? Now, the task of this and the next lecture is to see whether, despite the paradox and the two problems, any kind of legal amoralism can be sustained. I think it will prove possible to show that the paradox is in the end not too paradoxical, and that the problems end up being non-problems, provided that we seek to defend only a qualified kind of legal amoralism, but an important kind nevertheless. What I want to do first is to examine and explain legal amoralism and the case for it. Then I'll come back to the problems at the end of tomorrow's lecture and triumphantly dismiss them. And you will then also discover who shot J.R. I'm afraid that what I say is going to have, therefore, since I have only 2 lectures to say it in, pretty broad brush stuff, pretty underqualified, at least to begin with. I want to state cases plainly and simply, and without all the scholarly qualifications that will in due course, when these lectures are published in the Valparaiso Law Review, be necessary to make. So let me put it fairly broad brush, fairly blunt and plain. If there are doubts, questions or queries, we will, I understand, have a for questions after the lecture, and at the end of the 2 lectures, at least some persons present will, I believe, be able to take part in a seminar to discuss the theme more amply. However, I'll be as blunt as I have to be to keep up with my schedule and try to avoid losing all my bits of paper. Let me then turn to the defense of legal amoralism. As I said to begin with, there are 2 points in it which are going to have to be defended. Point number 1 and point number 2. And as I said, in defending point number 1, I shall have to try to show very quickly, in about 15 minutes, what law in its own nature is, and that it is indeed neither identical with nor a simple segment of morality. You will thus be present at the breaking of a world record when a question which has hitherto not been answered in 2,000 years will be answered in 15 minutes. And in showing that law and morality don't have to be identical, I will be trying to demonstrate what we may call today the positivist thesis. Let me just put that down here to show you the shape of this thing, if it has a shape at all. The positivist thesis that law and morality don't have to be identical. And then, as I promised you earlier, in showing how law, having the nature it has, ought to be framed and used, ought to have a certain content, in particular showing that it should be kept distinct from morality, I will be trying to prove a second thing, or establish a second thing, namely what I call the moral disestablishment thesis. Hopelessly illegible to all those at the back of the room. That's visual aids for you. So, in other words, legal amoralism turns out to involve defending the thesis of legal positivism and the thesis of moral disestablishment, or put it the other way, what I'm calling amoralism, legal amoralism in these lectures, is combination of legal positivism and moral disestablishment. And the difficulty about that is that we're going to have to deal with the paradox I mentioned, and we're going to have to deal with these 2 problems. So let me then turn to discussing the positivist thesis, trying to establish it, or at least sketch out how such a thesis can be established. Legal positivism, we may say, is a doctrine about the nature and sources of law. As to nature, law comprises normative rules, rules of conduct, and rules relating indirectly to conduct. These rules we have to acknowledge as being backed up by other normative standards, principles of law, sometimes even principles of justice, principles of fair play, policies, public policy in the law of contract, values of various kinds, values like reasonableness in many spheres. So that the nature of law being that systems of law are systems of rules, it has to be added, as Dworkin and others have been insisting lately, that it's not only rules, and that many other and important things such as principles, policies, and values come into the law. The second point is that these rules depend upon or derive from certain sources. For example, a constitution, as in the United States, or rather really, I guess one should say, as constitutions, namely the constitutions of the several states and the Constitution of the Union. And behind that, custom and usage of a people. It's not that a constitution was adopted in 1787, but that it has been the custom and usage of the people of the United States to refer their disputes to that constitution, which makes it an operative and effective source of law here in these United States. And the same, one could say, variously, for any other polity, what one cares to think of, any other polity living under law. So, law is what is sometimes called institutional fact. Fact, in that it is how people carry out government and are governed in working human communities. Institutional, in that it depends on human conduct and human attitudes to conduct as comprised in the customs, usages, and practices observed by people in political communities. Now, of course, when one says that, one should not be making some bland assumption about universal consensus. Custom, which constitutes political communities, is, as Herbert Hart and others have pointed out, primarily the custom of an official class or group within the community, the very people who hold positions under the Constitution, which is constituted a constitution by their practices and usage. So there's a kind of a logical circle in the argument, but many of us think not an unbreakable, not a logically unbreakable one. But the custom, although it's desirable for it to be wide-ranging, and most desirably of all under problem B, universal, the custom is not in fact in any known community universal, nor should we expect it to be in real life anywhere so. So, law is institutional fact and institution, and as such, not necessarily moral. Legal systems will, of course, include moral elements because dependent upon practical attitudes of legal and other official agents and of citizens as well. Legal systems may overlap with, because explicitly incorporating moral elements, as in the United States with its Bill of Rights, or Canada with its Charter of Rights. And of course, in applying rules and rights, even in countries which don't have institutionalized bills or charters of rights like the United Kingdom, we will be having recourse to principles and policies and values in interpreting and applying and using the law, and to that extent morals will have a bearing on the law, but it won't be the case. And this is my point. Between law and the kind of definition I'm pursuing, 2 points follow from what I've been saying. First of all, for some rule L to be a law does not entail that L is a law which it is in fact morally obligatory or even morally permissible for the authorities of a state to implement, and L is a law does not entail logically that L is a rule which it is morally obligatory for citizens of the given state to comply with. In both cases, both as to the justifiability of official enforcement and as to the obligatoriness quoad the citizen, those charged with operating the system will almost inevitably, and perhaps logically, be committed to claiming that they're morally justified in what they do, and to claiming that the citizen is morally obligated. But our definition of law leaves it open to the possibility that this is not so, that there is no real justification for official enforcement and no real obligation on the citizen. Because, of course, the kind of definition of law which I've given you leaves it the case that, for example, in Germany during the period of Nazi rule, there was law, there were rules requiring officials to take actions against people of Jewish race or origin, and there were rules requiring people of Jewish race or origin to report themselves to state authorities. Nobody would say that these were, at least almost nobody would say, that these were morally justified laws, justified in their implementation by the authorities, nor obligatory upon the citizens, upon whom they purported to be obligatory. Yet, on this approach to law, they nevertheless count as law. And the thesis that laws are rules which have sources and the sources depend upon custom shows that it is possible to give such a definition of law. But that it is possible is not conclusive of the question whether it is desirable to accept the definition. And many, faced with, for example, the consequence that Nazi law counts as full dress law, reject it and say that into the definition of law there should therefore be worked an explicit minimum moral element that, in addition to being dependent upon sources and comprising normative rules, law has to be at least justifiable to implement. This would result in narrowing the concept of law down somewhat by adding further criteria for what counts as law. And even just to have mentioned the Nazi case is, of course, to have given a reason why this would be a not unattractive narrowing down of the definition. Some people, however, and I'm one of them, want to resist that narrowing down. The kind of reason why we want to resist it has been very eloquently stated by Professor H.L.A. Hart at page 206 of his book, The Concept of Law. He says, "So long as human beings can gain sufficient cooperation from some to enable them to dominate others, they will use the forms of law as one of their instruments. Wicked men will enact wicked rules which others will enforce. What surely is most needed in order to make men clear-sighted in confronting the official abuse of power is that they should preserve the sense that the certification of something as legally valid is not conclusive of the question of obedience, and that however great the authority of majesty or authority which the official system may have, its demands must in the end be submitted to a moral scrutiny." In other words, if we accept conceptually the narrower definition of law, we increase the power of the symbol law in the hands of the agencies of state, wherever the state may be. If we insist that all that makes something law is the rules and the sources point, then we retain this as an open question. We remind people always that what is done in the name of law comes under moral scrutiny. We assert the sovereignty of individual conscience against the state and the need for perpetual vigilance against abusive conduct by public authorities. So, upon that argument, we may say that not merely is a positivist case possible, but it is one which it is desirable to accept and support. Notice, however, that if it is the only argument in favor of positivism, it reinforces the paradox, because not merely point 2, but now we discover point 1 as well, depends upon ultimately a moral argument as to how we should use concepts. Now, there are one or two other arguments for legal positivism, but I might as well cut the matter short for these lectures by saying that I personally find them unpersuasive, and that if, but only if, this moral thesis can be established, can the positivist thesis be established, so my sense of paradox is yet further reinforced. I move, therefore, to the final part of this lecture, to the question whether one can justify the thesis about moral disestablishment. The thesis that, in view of its essential nature, law should be kept distinct from morality, or just law and morality should be kept distinct. Why should they be kept distinct? Let me pick up again a theme which I've already mentioned at the beginning of the lecture. The theme of religious disestablishment in the sense intended in the First Amendment to your Constitution, the principle of religious disestablishment, so if I may say so without sounding patronizing, brilliantly expounded and criticized by Professor Levinson in her inaugural lecture. Mark de Wolf Howe, in his book The Garden and the Wilderness, drawn to my attention by Jack Hiller, points out that there were historically two arguments, two reasons in the minds of the early citizens of this land in favor of the principle of religious disestablishment. The first one, favored by Roger Williams and others in New England, was the thought that the state ought to be most sedulously kept out of religion. The last thing churches need is politicians meddling in their affairs. Only if the church is kept a garden with the wilderness of politics walled out around it will religion and true belief survive and thrive. So, as it were, the quality of religion is such as to call upon us to wish for disestablishment and keeping the hands of the politicians out of the affairs of the church. Good religion, real religion, is uncoerced religion. Real religion is voluntarily confessional. And the moment states start exacting tithes or enforcing attendances at services or prayers in the morning in schools or whatever, that moment, the independent and voluntary principle in religion is gone. That's one sort of argument for religious disestablishment. And the other one, which Thomas Jefferson, I believe, supported more strongly, Thomas Jefferson, who was the real father of this provision within the Constitution, was the converse one, that you should keep the clerics out of politics. A healthy state is not a monkish state. A healthy polity is one in which political decisions are taken for political reasons, leaving religion and matters of conscience to their proper sphere, matters of religious conscience to their proper sphere, but not allowing the wise conduct of the affairs of the polity to be corrupted, biased, or otherwise distorted by the imposition of one or another set of religious tenets through the force of the state upon people who might otherwise reject that or any religious tenets. So there can be two kinds of reasons for wanting churches to be disestablished, and in your country, and indeed to some extent in mine, these reasons have had a powerfully persuasive effect over the history of the societies we know. And the moral disestablishers might say very much the same thing, and indeed have said very much the same thing. First of all, keep the politicians out of ethics, as it were. Morality, like religion, it can be argued, is a matter of conscience, a matter of the free and uncoerced sense of right conduct among human beings. And we should be preserving the conscience of each of us as citizens of a free community so far as we can. Secondly, we should be anxious to allow moral, like religious truth, to be pursued, but, as it is often argued, the best way to allow a pursuit of the truth is to allow a flowering of as many opinions as they are, in order that the critical insight of the citizen body, the people, can be brought to bear in a kind of naturally selective process upon various creeds and tenets and arguments and views, and only by allowing this free competition of ideas will we get at the truth in matters religious or in matters scientific or matters of any sort whatsoever. Then in particular, as Kant and his school would argue, and John Stuart Mill as well, though, we ought to be on our guard against turning morality into a kind of heteronymous matter of external observances. What matters is not just that people do the right thing, but that they do it because it's right and because of their commitment to its rightness. So if you want a community of moral beings living together, you should not want to be coercing them into some line of behavior on the ground of its morality, because in a kind of anti-Midas touch, you turn to lead whatever you lay the hand of state coercion on. Finally, again, one just might want to respect honest differences in a free society. One might not wish any one vision of the good life for a human being to be laid down and imposed upon a whole community, because some of its members adhere to that as the best vision of the good life. So on these and all these sorts of grounds, one might wish, as it were, to protect the garden of morals over against the wilderness of politics, and the desire to protect the independence and autonomy of a moral sphere would be a reason for proposing moral disestablishment and opposing any kind of moral establishment. Secondly, of course, one might analogously want to protect the law itself from the intermeddling of moralists. For really what law is there to do is to secure to each individual, to all individuals, their own spheres of freedom, of free action, of uncoerced action, and to secure that the freedom the law gives us is reasonably equal in value among all of us. Now, of course, exactly how to get as much freedom as possible and as fairly equal value of freedom as possible is a great dispute, great matter of dispute. Those who are in favor of the night watchman state, the the move from state intervention in economies to state out of the economy think that freedom and the value of freedom is secured that way. Those who retain the more social democratic view that some qualification of abstract freedom is necessary in order to procure some reasonable equality in the value of freedom for citizens, both have, in the last resort, I think, similar and ultimate values in mind, although they deeply disagree about the political tactics for pursuing them. But so far as the argument goes along these lines, the idea is that the law is to create people's chances of pursuing their own happiness, not to tell them how to do it, and moralists intervening will distort that purpose. In the presence of Professor Britsky, I must add also that some at least would hold that a proper purpose of the law is to create the conditions for the maximization of the economic goods available to the members of a community. And although, again, it's a hotly disputed question, it's between neoliberals and social democrats or whatever, how exactly to do that, and how to do it consistently with fair or reasonable distribution of goods, yet I think it would be commonly held to be in and of itself a good idea to let the law be used in such a way as will assist us to maximize economic well-being, economic opportunities. It's a good thing if people are well off. And there's an old Polish proverb which says, it is better to be young, happy and rich than old, unhappy and poor. So, looking at the case for moral disestablishment, one can see that however you come at it, there's at least a terribly good argument based on what one might sum up as the sovereignty of conscience, the sovereignty of individual personal conscience, the right to an independent definition of the good life, or the right to what Ronald Dworkin calls moral independence, as underpinning our idea that we don't want kind of moral establishment any more than you in your country want religious establishment. So we come to an interesting thought, at least a thought which interests me, that after all, the positivist thesis and the moral disestablishment thesis both depend on, or can be made to depend on, a similar argument from a similar value, the value of the sovereignty of conscience. That brings me to a point which would leave us to do certain things tomorrow before we can leave this topic off. First of all, I have to confess that, as the other assiduous student of my works and I know, I feel there are still some difficulties in the case for moral disestablishment as I've so far disclosed it to you today, and I need to confess to these difficulties tomorrow and see if we can do anything about them. And then I need to check whether that confession and this tinkering messes about at all the case for the positivist thesis. And having done that, I will be able to give my explanation of the qualified character of the legal amoralism which I want to support. And then, finally, I will be able to show how, having thus qualified it, I can overcome and dismiss these problems which I have laid before you today. Anyway, just to conclude, to remind you where we've got to today, that's my definition of legal amoralism, and the case I have put for it depends upon a doctrine about the sovereignty of individual conscience, the right to independent judgment and independent expression of judgment. And I'm therefore particularly moved to quote to you, in conclusion, words of Mr. Justice Oliver Wendell Holmes, Jr. If there is any principle of the Constitution that more imperatively calls for attachment than any other, it's the principle of free thought. Not free thought for those who agree with us, but freedom for the thought that we hate. It's a powerful point. Not for me made any less powerful by the fact that it occurs in a case, the third point of the head note of which, or the second point of the head note of which reads, in order to safeguard against admission to the United States of those who are unworthy or who for any reason fail to measure up to required standards, the law puts the burden upon every applicant to show by satisfactory evidence that he has the specified qualifications, and if you will come along tomorrow, I will discharge that burden.
I think there is a problem in words chosen which might create a fallacy there, and do not have to be does not logically relate to should be kept, because when they are identical, I don't see how you can keep them distinct, though when they are not identical, they may of necessity have to be kept distinct. So consequently, I don't see how one can say that the two don't have to be identical, but should be kept distinct.
I'm very, very grateful for that question, if I may say so, because it really helps me to get clearer exactly why I wanted to make these 2 points quite different points. I say that they don't have to be identical, that they have to is, as it were, ontological or metaphysical. It is not of the nature of law and of the nature of morality that they are necessarily the same with each other. Now, of course, only if that proposition is true is the second one significant, as you said, because if they were one and the same thing, then it would be crazy to bother about whether they should be kept distinct or not. I mean, if I were to suggest that bachelors should remain unmarried men, it might rightly be said that I've uttered a rather vapid view, because bachelors are indeed identical with unmarried men. Now, what I want to say is that there is no logical or conceptual or ontological identity of law and morality. That's point one. And point two is to argue that they, being not identical, should for some other reason be kept distinct. What is curious is that as far as I can see, and I may be wrong about this as well, the deep argument for the ontological position turns out to be, after all, a value argument, and the same one as is involved in the second one, which, again, I agree with you, is highly contestable in both cases, but this is the contest we're into.
Professor MacCormick, I wondered if I might call your attention to what seems to me a kind of a tension between two of your arguments. It seems to me one of your arguments was that one might say temptation is a morally good thing. In other words, temptation builds character. It's better that we be on our own to do what is right morally, rather than have the law come in and remove temptation, either by eliminating what might be the dirty magazines or punishing us for reading the dirty magazines, somewhere making it easier for us to do. In the case where we agree with the law, morality we agree with, it's bad to have the law on our own, to be tempted, temptation, make a personal choice. But I also heard you, laws which are personal moral beliefs are bad, are morally bad for us, because it's morally important for us to express our moral beliefs, and we are more likely to express our moral beliefs if we are not punished for them than if we are. Is that temptation is bad for morality, that yes, the temptation is bad for morality. We should cause that make it too hard for us to be. But the first argument, by golly, it's hard to be. I mean, isn't the best situation for building character to be in a moral minority, where you really are terribly tempted to go against your moral beliefs, but you fight it out? I mean, how unheteronomous can you be? Anonymously stick up for your values. So I see it. What is the relationship between temptation and moral development? I see a tension in the two.
Yes, I guess there may be a point here. Maybe there is no accident that the Scots at least became among the first proponents of Calvinism, and they tried to invent Gaul. Because the point you make is very like the point that Jack Hiller makes about the terrible thing about having to do the right thing behind the tree when nobody could see if you did the wrong one. To be serious, the first point, that there is some suggestion that, as it were, temptation is character building on the one hand, and that version is objectionable on the other hand. And there's at least a tension. I think you're probably right not to say a flat contradiction between these two propositions. I don't myself think that the moral autonomy thesis needs be pressed the length of saying that temptation is actively to be or in order that one can, as it were, do one's moral Swedish exercises in resisting it and building up one's moral muscles. I don't think that that necessarily is true. The point really, however, is that being left, as it were, freely to choose the right thing, perhaps hopefully without too much temptation around, is a better state. Certainly the Kantian view of things is to that effect, and I think also the Millian view. So interestingly, the kind of utilitarian strand in Western thought and the Kantian strand in Western thought come together on that point. On the other hand, as it were, the proponents of this view do not press it the length of, as it were, actively seeking martyrdom, wanting to be put in jail in order to show how devoutly they hold the view they hold. And actually, I think martyrdom seeking can generate a kind of dangerous fanaticism even, so one which is yet more hostile to the kinds of values that I want to argue for in these lectures than anything else. So that I think that I can just about steer a middle way by saying, well, indeed, it involves an acknowledgement that temptation will be around us, and that this is a price we have to pay for autonomy, rather than a virtue of autonomous morality. On the other hand, saying, and we don't want martyrdoms either. People should not be coerced, should not have to face pains and penalties for acting conscientiously, so far as it is reasonably possible to prevent imposing pains and penalties upon people when they act conscientiously. Now, I'm compatible, though I'm very grateful for the not obvious tension between these two positions. For the
pregnancy
profound questions.
I agree with you. I think that this is the right point at which to start tomorrow's lecture, and maybe the right point at which to stop today's questions.